With Saturday's death of Justice Antonin Scalia, the most important conservative voice on the court in decades, the nation may be heading into a constitutional crisis. Senate Republicans vowing to block President Obama from filling Justice Scalia's seat. We're joined by three guests. Linda Hirschman is still with us from Phoenix, Arizona, lawyer and historian, author of Sisters-in-Law, How Sandra Day O'Connor and Ruth Bader Ginsburg Went to the Supreme Court and Changed the World. We're joined here in New York by Scott Horton, human rights attorney and contributing editor at Harper's Magazine, a lecturer at Columbia Law School. In a moment, we'll be joined by Kimberlé Crenshaw, professor of law at UCLA and Columbia University. We're going to turn, though, to Scott Horton.
Scott, I wanted to ask you about Scalia's last decision, which was on a clean power case last Tuesday. He was a decisive vote on that as well. Could you talk about that?
Well, I think it's clear right now that that injunction that was issued by the Supreme Court would not have been, wouldn't be issued today. His vote was essential to get it over the hump, and that was a radical move. There is really no precedent for the Supreme Court issuing an injunction, staying pending argument in the Supreme Court, regulations of general applicability of this sort.
But just to be clear, this was struck down regulations of coal-powered plants, which was really the centerpiece of the U.S. position at the UN Climate Summit in Paris.
Precisely. And in fact, I think this decision got more attention overseas than it got in the United States, because we saw a number of European nations focused on the fact that it looked like the Supreme Court was going to block United States implementation of the Paris Accords, because these regulations were right at the core of it. And now there clearly is not a majority within the Supreme Court in support of that injunction. But we're going to have to see, either there'll have to be a motion for rehearing of the matter by the Solicitor General, or we'll have to await the final decision. But it's no longer as clear that the situation's ominous for Barack Obama on these regulations.
Well, let's turn to Kimberlé Crenshaw, who is just joining us from Santa Ana, California, professor of law at UCLA and Columbia University. The significance of the death of Justice Scalia.
Well, Amy, I think this is probably the most significant thing to happen on the Supreme Court, at least in the last 3 decades since he was actually appointed. But I really think the challenge in the way we talk about it is being able to make it clear that while Justice Scalia was enormously influential, and some will even say he was an interesting person, what's not really being said as much as it should be is just how devastating his legacy is. What many people, I think, don't really understand is how much their rights really turn on the interpretation of the Supreme Court. And in that context, Justice Scalia was a person who effectively bludgeoned the life out of the living Constitution, the Constitution that gave us desegregation, that gave us women's rights, that gave us environmental protections and political access. So when we think and talk about his influence, we have to think about it and talk about it in ways that give people a strong sense of how significant his judgments were, and what this moment presents an opportunity to do, which frankly is to recover or reclaim some of what made the Constitution so powerful as a source for equal rights.
And Kimberlé Crenshaw, we've asked the other guests, but I'd like to ask you also your sense of what this means in terms of the possibility that we now face a potential gridlock in the Supreme Court, similar to the gridlock we have in Congress in terms of being able to get things done as a result of partisanship?
Well, I agree with all the other guests that what we're looking at, if Mitch McConnell is able to really stand firm on his claim that they will delay, there will be chaos. And within that chaos, there will be some victories that might not have happened, as always, is the case when you have the Supreme Court in the position of merely affirming some of the decisions below. But I really think that the more fundamental opportunity that this presents is to really point out that the original originalist claim is truly an ideological one that is more directed to particular outcomes rather than any coherent position. I mean, the Founding Fathers would be appalled by the claims of Mitch McConnell and many of the Republicans that the president doesn't have a role to play in nominating a replacement, and the Senate can just choose to delay because they don't like the potential ideological direction that this nomination might represent. I think it's important for the American people to know that the position of originalism isn't itself an originalist position, and this is the opportunity to understand that and see what difference it makes in how we go about thinking about the Supreme Court.
I mean, isn't it true that probably they understand that President Obama is going to nominate someone? I mean, in the last cases where there's been the announcement of someone retiring, he's announced a name within 30 days. So it's pretty clear he's going to move forward. But what this does, this kind of pressure does, is it pushes him to name a more conservative candidate for the Supreme Court. And I wanted to ask Linda Hirschman about one of the cases that's coming up very soon on March 3rd, the case of Whole Women's Health, on March 2nd, the case of Whole Women's Health in Texas. This is a case of abortion. Can you explain the significance of this case and what this Scalia-less court will do?
So the Whole Women's Health case involves a very onerous law in Texas, which requires abortion clinics to have affiliations with hospitals that they simply can't get, and would mostly drive most of the abortion clinics out of Texas, creating an abortion-free zone in Texas. The lower court is the red or conservative Fifth Circuit, so they had said that the law was good. And there was some betting about whether the Supreme Court would break 5-4 with Kennedy switching to the liberals to strike down the Texas law. So the question now is essentially again on Kennedy. If Kennedy switches to the liberals, then the law will be struck down 5-3. If Kennedy stays with the conservatives, then the court will, exactly as we've been.
We just lost Linda Hirschman. We lost the satellite in Phoenix, Arizona. She is the lawyer and historian, author of Sisters-in-Law, How Sandra Day O'Connor and Ruth Bader Ginsburg Went to the Supreme Court and Changed the World. Can you finish your thought, Scott Horton?
Well, the alternative is that there's an even split, 4-4, and the ruling of the Fifth Circuit stands. And that accentuates, again, the likely evolution of a divided country by judicial districts. The more liberal, the blue courts of appeals will probably strike down efforts to undermine abortion rights, whereas the red courts of appeals will sustain them.
Well,